You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello and welcome along to the latest Today's Family Lawyer podcast. Today I'm talking with Paula Backen. Paula is an experienced intermediary, mostly in England and Wales, although you've done some work internationally, you were telling me, Paula, based in Birmingham. And the discussion today is all around your role as a court's intermediary. I'm not going to say any more because one of my first questions is going to be exactly what your role is. But it's fantastic to have you on the podcast. I really, really appreciate you joining.
Thank you. And thanks for inviting me. You want to know a little bit about me?
Well, let's start. Yeah, tell us a little bit about yourself and your role as an intermediary.
Okay. So, I'm based in Birmingham. I originally qualified as a speech and language therapist over 40 years ago. And basically, as a speech and language therapist, I was expected to be an expert in communication. And about 11 or 12 years ago, I was asked if I would like to explore a new challenge, really, as an intermediary. And at the time, there were only what were called registered intermediaries, which were for criminal witnesses only. And that was a scheme that was set up in 2003. And since then, I have worked across the board. I've been over 60 Crown Courts, Magistrates Courts, Family Courts. I've just started working in employment tribunals. So huge range of different roles for an intermediary. But essentially, they're all the same. They're all about advising the court on communication with people who are vulnerable. The family courts have only really picked up on using us, I would say, in the last maybe 7 years. And I did one of the first cases back in Bristol, I reckon about 7 years ago, but it has grown enormously.
What was that first case all about, Paula, and why were you in particular involved in that?
Well, at the time I was working for the biggest agency of intermediaries, and we got a request for assisting in a family court. And it was very interesting because it became obvious to the QC, now KC, that this mother could not cope with the proceedings and would not be able to actively participate without some assistance. And I think there had been some involvement of advocates to assist people. But the difference between an intermediary and an advocate, and maybe we need to talk about that in a bit more detail, is that we are officers of the court who are employed to be impartial. We're not part of the case on anybody's side. And our role is not to advise on the case in any way. We're not legally trained, and we're not there to provide the emotional support to the individual. Our role is purely about communication. However, communication is impacted by lots of different things. So it may be that we advise on things that help to manage somebody's emotional regulation during a court case. But we wouldn't be the person who travelled with them to the court. We wouldn't be the person who worried about their lunch. But we might be interested in when they take their medication, because if they take their medication at the right time, they're more likely to be able to participate effectively. So it's a very fine line there. And this case, they had realised quite rightly. And it was interesting that at the end of the case, which took about a week, the QC stood up and said to the court that he thought that, having seen the impact of an intermediary that week, he thought this lady would need an advocate to help her the rest of her life, and certainly while she was parenting a young child. And her child went back to her, and there had been a lot of miscommunication that had gone on because nobody had quite recognised her needs.
I think you've neatly defined the difference between the intermediary and the advocate. what's the difference between the intermediary and the expert witness? Because again, there's potential for crossover there, isn't there?
Mm. Yeah, I think it's a really important point actually to establish that an expert witness will give you partial advice on the person's competency and skills and abilities that are general and related to their life skills, and maybe impacting on their parenting skills. As an intermediary, what I'm interested in is their specific communication skills in relation to court proceedings. So, for example, I may advise the court that the person doesn't cope very well with new information unless it's broken down into small chunks. Now, that will be really important in the court environment because there's no visual aids, because it's not in context. You're not trying to change a nappy at the same time or make a bottle. However, I find, and this is my personal experience, is that sometimes the information we give ends up as evidential in a case, which it's not supposed to be. And I think there is a very fine line there. And I do worry about once an intermediary is appointed, that the view of this respondent, usually a parent, is that if they need an intermediary, then they couldn't possibly cope out in the real world because they need an intermediary for court. Where actually court is a very specific thing and it's not the same as being out in the real world.
Given that this role has only really come to prominence, as you say, particularly in family over the last 7 years, perhaps, why is that? Why haven't there been intermediaries involved in family cases before then? What's the trigger?
It's interesting. I mean, I've spoken at family law conferences and things like that where it started to be picked up. Essentially, the involvement of intermediaries in any case is so dependent on which solicitor takes the case and whether they've ever known an intermediary or know about it. So there is a huge inconsistency across the country. And within, towns or cities, you might find that there are particular solicitors firms that request intermediary assessments and others that don't ever. And there's something about just that consciousness amongst the legal profession that it's no good just saying to a respondent, let me know if you don't understand. Because if you've got to the stage of being a parent, you have had a lifetime of working out how to hide that you don't understand. And the last thing you want to do is look stupid. So you don't say. And most of the people I work with are perfectly intelligible in their speech. They look okay. They walk in the room and you don't go, oh, look, there's somebody who needs help with their communication by looking at them. We're not talking about people in wheelchairs. We're not talking about people with cerebral palsy who struggle to get into the room. We're talking about people who look okay, who may be sat at the back of the class throughout their education, who maybe went to special needs schools but never properly learnt to read or write. And most of them have never been employed. And nobody's picked up on this. And it's happening in criminal courts too. But I would say that the family jurisdiction has warmed to our involvement much quicker and much more positively. They've been very keen to have our involvement, which is lovely. I have colleagues who would rather work in family courts than criminal courts because of less adversarial approach, more collegiate, more willing to engage with us, makes things a lot easier. So thank you, everybody.
So there's a growing need for intermediaries, which you've sort of
Yes.
identified. Is there a sufficient supply of people like yourself out there at the moment to meet that demand?
Right, you know the answer to this, because is there a sufficient supply of anything at the moment, from nurses to barristers to everything in between? No. Basically, there weren't enough for the criminal jurisdiction, and then family started to grow, and family takes up a large percentage of the work now, far more than criminal, partly because criminal judges may sometimes refuse us, whereas we are very rarely refused in a family court. So in terms of supply, there is a shortage. I should explain something that may be obvious to your listeners, but maybe not to others, that in April this year, 2022, HMCTS made a decision to set up contracts with suppliers of intermediaries, essentially 3 main suppliers, plus some individual intermediaries who have individual contracts, so that the whole thing can be more regulated, because it was quite an unregulated world. So we can manage the quality control, we can manage the recruitment and the administration of those intermediaries. I belong to one of those 3 agencies, which is a cooperative. The idea is that now that each of those agencies will recruit more people, recruit and train. And some of the issues are, I come from a speech and language therapy background. The majority of intermediaries are similarly qualified. There's a shortage of speech and language therapists. So, you know, we've got a small pool to recruit from to start with. But there are people from other professions. There are special needs teachers, there are occupational therapists, some psychologists. You do need some background in understanding communication with people with disabilities.
You preempted my next question, actually, which is, where are you recruiting intermediaries from? You've suggested speech and language therapy and occupational therapy, that sort of thing. It feels to me as though this is possibly something that mediators could get involved in.
The skills specific to an intermediary are about simplifying language. And mediators generally don't work with people with disabilities. So I'm not saying that there aren't some mediators, and I know one in particular who is also an intermediary, and she does both. But there's something very specific about understanding communication impairments and understanding what might be going on. You know, you need to understand what working memory is. You need to understand what aspects of auditory comprehension are needed. You need to be able to assess somebody's literacy. And the very key to our role is that when people are first referred to us, we carry out an assessment, which is just ourselves and the respondent, usually respondent, where we assess their communication and prepare a report that has both the results of that assessment and our recommendations. Now, a mediator wouldn't be able to do that because they couldn't do the assessment of the communication. So when you say where do we find intermediaries from, or how are we going to train them, I think there are 2 routes. One is that you take people like myself who already have the knowledge of communication and run a short course, or you recruit people who have some social sciences degree, have some experience of working with disability, and have the intellect to cope with, you know, further study, and then you teach them in a longer training course. And that's what we haven't really got to yet. That, I think that's where the profession is progressing to, is that in order to have the capacity that's needed, we have to run longer training courses. For example, you don't need everything that you've learned as a speech and language therapist. You're not going to do therapy. You're going to work with the person in the environment they are in. And what's really important in our role is that it's not about changing the person with a disability. It's about adapting the environment and the people around to get the best from that person. So we don't need to make that person better. We need to make them more competent because everybody else has adapted to them. And that's, you know, that's human rights law, basically, is that we adapt to them.
To what extent has the role been complicated by things like use of video in courts, or has that simplified things for you?
During every aspect of COVID and the pandemic, it was very interesting how many family courts moved to remote hearings. And asked us to also do things remotely. And we said, well, we can be remote from the court, but we can't be remote from the person, the vulnerable person. because actually we need to sit in the same room as them. And I have been in situations where I've been told by court staff that I can't sit in the same room as that person. I have to sit outside it because of social distancing. Well, we found ways. We've used an interesting bit of kit. When you go on a tour, a walking tour, the guy leading it has one of those things where he talks into his mic and you can be ages behind and you got little earphones in. And well, we've tried using that system, but essentially we need to sit in the same room. We need to use visual aids, and we need to look at the screen with the person. So what's tended to happen is that we go to the solicitor's office. We don't go to people's homes. So we go to the solicitor's office and the vulnerable person comes there and we sit and remotely link into the court that way. But it has caused us some problems. And to be honest, the more we go into court, the better. Hybrid doesn't work when the vulnerable person is in the courtroom and the person asking them questions is on a screen, because that's also another weird communication environment.
Yeah, does that mean that some of the visual cues that you might normally use aren't there, which would make communication more difficult in itself?
Definitely. I mean, if you think of the layout of a courtroom, you're asking the vulnerable person to sit at the back and to not see the faces of the barristers who are speaking. So all they see is the face of the judge, and they've got no way of reading the facial expression or get any non-verbal communication. And in some courtrooms, we ask that we move to the side so that we can actually visibly watch as well as listen. And that, we all know that a high percentage of our communication is based on non-verbal. So it really does make a difference. You also have to think about the amount of written documentation that's used in courtrooms, and expecting somebody with very low levels of literacy to find their place in a document, to agree that they've read they signed a statement. There are so many things that are just assumed in a courtroom.
The litigant in person is often cited as one of the key reasons for delays in the courts. There's an obvious answer to this, but how is this exacerbated when the litigant in person is somebody vulnerable who needs the assistance of an intermediary?
It's a big problem, as I'm sure you've thought it probably would be. Just to be clear, because we are not legal advisors in any sense, we are impartial and officers of the court. For us to sit and be with a litigant in person outside of the courtroom is really quite difficult, because it would be very easy for them to say that we had advised them to take and nobody else heard the conversation. So we could easily get into a position where we're being sued for the way we're advising. There are some intermediaries who feel okay about doing this, but I have to say my personal preference is that if we are going to be involved, we only meet with the litigant in person inside the courtroom where it's being recorded, and where the judge has set some ground rules about how that will take place. I have done it a couple of times. To be honest, I don't quite like it. I can't be their spokesman. I can't take what they've said and turn it into something else. So it is very difficult to do, and it does cause delays. It's a problem. The lucky thing with most of our vulnerable people is they're more likely to get a legal aid.
And to what extent, dare I ask, do you understand some of the legal aspects of a case, or do you have to understand the legal aspects of a case in order to act as an intermediary?
That's really interesting. I think it's really important that we don't get to be too knowledgeable. And I think it's very hard for somebody who is legally trained to become an intermediary. We have some really good examples of it, and it's possible. But I think it gets in the way a bit, because you don't know what you don't really know what other people don't know. So it's about knowing enough of the legal process and what the vocabulary means, but not knowing always what a specific law or certainly not a specific case is about. Some of my colleagues like to read the whole of a case bundle to be involved. Personally, I don't even think we need to do that. They have legal, well, if they're not litigants in person, they have legal representation and other people to explain that to them. I prefer to just be that conduit between what the legal person is saying and what the respondent is saying.
And you talk about the fact that HMCTS have placed contracts with a number of intermediary organisations now. Is that a step in the right direction? Do we need to extend that further?
It's definitely a step in the right direction, and they admit, HMCTS, that this is a first step in them understanding what the needs are, because until now they've had no way of collecting information. And so one of the big benefits to them is they now have management information, which hopefully they are able to digest and process. They had no idea which courts, how many, how much time, how much they were spending, none of that. They had no idea. So it's a step forward from that point of view. It's also a step forward because the way they are paying us as agencies is more than is expected to be paid to the intermediary as an individual, and should cover, it's like an uplift in order to cover the costs of managing quality, managing standards, recruitment, training, retention, all those things. So basically they've outsourced it. They've said, let's outsource that service. We don't really know enough about it to run it. And the fees are based on what we need to run the organisation. So to be clear, the intermediaries are not being paid what the fees are. That's something that maybe your listeners would like to know. We're also, in our organisation, we're all self-employed, but there is one of the organisations employs intermediaries. So they're on a salary basis, whatever they do.
How do you see then that the role of the intermediary is going to change going forward? Because it's still in its relative infancy at 7 years.
Yes, it's definitely, it's nearly 20 years since it started with witnesses in criminal courts. And it is definitely evolving, there's no doubt about it. I think it's very clear that with more training and more experience, some barristers will be able to simplify their language, change their approach, and may not need as much help from intermediaries. And I think we may have to look at that. I worry because part of legal training, to be a really good barrister, you have to learn how to be very precise with your language. And so you use lots of very technical words. And if you're then asked to simplify that, it can feel quite unsatisfying. I once asked a barrister if they could, it was in criminal court, but I said, could you not use the word obtain? Because the word obtain is not in this client's vocabulary. Could you say get or got? And the barrister said, but I don't mean got, I mean obtain. And it is quite difficult to change what you've spent years and years perfecting, which is how to be very precise. So I don't think it's possible for all barristers to change to that. But I do think we need to do more education, and I think more training for them. And then maybe we would need intermediaries less. The other thing I've noticed a lot of is that we are really, really useful in conferences. And sometimes it's more about the conferences and not about the hearings, particularly if they're very administrative. I've started to say maybe you don't even need the respondent there for the administrative hearings. What is the point if you're just setting dates? Let's have intermediaries involved in conferences and not so much in an administrative hearing. Clearly in a final fact-finding hearing, yes. And that might change the way we work.
That would be really interesting. The other thing that I'm sort of thinking here is that this has got applications across a whole swathe of the law. You've talked about criminal, you've talked about family. Listeners will be aware that we have a Today's Wills and Probate publication. Contentious probate feels like a very obvious forum for intermediaries.
Yeah, absolutely. I've just started doing employment tribunals. There are requests for coroners' courts there. It will grow. And it is about us starting to realise that what is really a hidden disability, communication impairments, needs addressing. And it's no good saying we've put a ramp in for the wheelchairs, so we've addressed disability, but what we haven't done is recognise that those people who look like you and me may not be able to cope with the level of communication needed in a courtroom.
I think that's a really neat summation of the conversation, actually, that this is about identifying those hidden disabilities and just supporting people to whom it doesn't come particularly naturally. We could probably talk about this for most of the rest of the day. We've run out of time. I can't thank you enough for joining the podcast. It's been brilliant to chat through what is obviously a changing environment.
Thank you very much for inviting me.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to Paula. Thank you for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.